Good afternoon, ladies and gentlemen. I call to order the 3,388th meeting of the Human Rights Committee. In this round, first the members of the committee are going to ask follow-up questions, and then right after the follow-up question, the question for this final round. The first member in the list is Mr. Benashur. Mr. Benashur, you have the floor.
Merci, Madame.
Thank you, Madam Chair. I don't have any follow-up questions, and so I will move on to issue 20 and 21, which I'm going to deal with together because they are both issues that are very closely related. I'm looking at my watch to check that I keep to time. It is the issue on freedom of religion, conscience, and belief. That is issue 20, and issue 21 looks at the provisions of the criminal code relating to blasphemy. The state party tells us that in order to fight religious intolerance and hate speech, Pakistan adopted Law 2016 with committees to monitor and prosecute religious intolerance and hate speech. So that shows a political will on behalf of the government of Pakistan to deal with the phenomena of extremism in religion and religious hatred and hate speech. And for the good points of this issue, there is a Ministry for Religious Affairs, but not just for religious affairs. It is a Ministry for Religious Affairs and for harmony between religions. That should be noted because it shows a political will to fight intolerance. The government of Pakistan also tells us that there are reforms within the Madrasa to ensure that the Madrasa modernize and update their teaching. And the government tells us in paragraphs 65 and 66 that measures have been taken. I beg your pardon, says the Speaker. The government tells us that the second amendment of the Constitution on Article 263 of the Constitution of 1973, through this amendment, the Ahmadi community now has the statute of a religious minority and so benefits from freedom of belief and religion. On the blasphemy law, I'm going to be rapid. What we must retain from everything that was said in the report from the State Party is that the National Commission for Human Rights presented a report for the amendment of the law on blasphemy to avoid its being misused. So the reports from the Human Rights Commission are currently being examined by Parliament. Now, I would just like to make the following remarks quickly. I have two series of important comments to make. The first series is in terms of the law, and the second in terms of practice of reality and facts. So the first level, the law. First of all, I would like to ask the delegation about the idea of submitting the law to religious rules. Is that compatible with the idea of freedom of belief and religion? The question that I'm asking is to know if the role of a constitution is of defining who is a Muslim and who is not. And that in the Constitution of Pakistan, there are definitions of what is Islam and what is not Islam, and so who is or not Muslim. The second comment is that there is an Article 20 in the Constitution which recognizes the freedom of conscience. But some constitutional provisions don't follow the same line. In particular, Article 2A, 263A and B. In accordance with the Second Amendment of the Constitution, the Ahmadi are not considered as Muslims. And this Second Amendment is aimed particularly at the Ahmadi. And my question is the following. Does that not constitute interference of the state in freedom of belief? Now I'm going to come back to the law on blasphemy. In the Pakistani Criminal Code, there are provisions which sanction attacks on religion and the sacred. For example, Section 295B and 295C. They include articles concerning blasphemy, that is profanity or profane treatment of the Quran, insults to the Prophet, and they can lead to imprisonment and also capital punishment. Section 298 sanctions attacks on religious sentiments, religious feelings. Section 298A penalizes insults or attacks to the spouses or the family of the Prophet, and Section 298B and C target in particular the Ahmadiyya, the Qadiani and other groups, and thus penalizes their request to be considered as Muslims. So in accordance with these articles, 298B and C of the Criminal Code, they may not call themselves Muslims, although this community says it is Muslim. On this whole series of laws on blasphemy, the Special Rapporteur on the Independence of Judges and Lawyers, following a visit to Pakistan in 2012, estimated, and I'm going to quote the Special Rapporteur, these laws serve particular interests of extremist groups. They are not just contrary to the Constitution of Pakistan, but also to the standards of international human rights law, in particular those related to non-discrimination and freedom of expression and opinion. End of quotation. And the Special Rapporteur recommended to Pakistan that they abrogate or amend the blasphemy laws in order to align themselves with the obligations of Pakistan under human rights law. So at the level of the law and the Constitution above all and the Criminal Code of Pakistan, there are problems which can affect human rights and in particular the freedom of belief and religion, Article 18 of the Covenant. Now, in practice, the social, political climate in general and social pressure are a true source of discrimination, in particular on the situation of the Ahmadi community. So by way of example, just a single example, on the 13th of April 2014, a student, Ahmadi Mashal Khan, was lynched at the University Abdul Wali Khan in Mardan. And the problem that arises is that within the social context, there is a certain aggression towards the Ahmadi community, but not just to that community. Certain other religious minorities, such as Christians or the Hazara, who are Shiite, are often subject to attacks in society on their temples, their mosques, and that thus it is that an Ahmadi mosque is currently closed. Why is that? What is the reaction of the delegation to this climate which is hostile towards religious minorities in Pakistan, and what is the government doing to overcome these aggressive phenomena towards religious minorities? Thank you.
Thank you, Mr. Benashur. Mr. Iwasawa, you have the floor.
Thank you, Madam Chairperson. I thank the distinguished delegation of Pakistan for giving responses to our questions. I immediately turn to issues for this afternoon. This afternoon, I will ask questions on issues 22 and 23. And they relate to the right to privacy and the freedom of expression, and I will deal with them together. As a legal framework governing data collection and surveillance, in the written replies, the State Party provided explanation on the Prevention of Electronic Crimes Act. I'd like to ask a question on this act. Concerns have been expressed over the legislative process of the act, in particular the lack of transparency and open consultation. Could the distinguished delegation please respond to such concerns? My next question relates to the powers given by the Act to the Pakistan Telecommunication Authority, PTA. According to information before us, the Prevention of Electronic Crimes Act grants carte blanche to the PTA to restrict access to information on the Internet without judicial authorization. Could you please explain how the powers given to the PTA by the Act are in line with the freedom of expression as provided in Article 19 of the Covenant? In the written replies, the State Party explained that the powers given to the authorized officers by the Act are in line with the Budapest Convention. But the powers seems to be very broad, and even though the Act provides certain guidance as to how such powers should be exercised, they're not subject to independent judicial oversight. Could you please explain how abuses can be avoided without independent judicial oversight? Next, I'd like to ask questions about sharing of information and cooperation with foreign governments. In the written replies, the State Party explained that the rule under the Prevention of Electronic Crimes Act, not requiring judicial authorization or oversight, was in line with the Budapest Convention. Could you please explain how the interception and sharing of data authorized under the Act are compatible with the right to privacy as provided in Article 17 of our covenant. The licensing requirements of service providers under the Act seem unduly restrictive. Moreover, the Act provides the PTA with powers to issue guidelines to information system service providers as long as it is in the interests of preventing an offense. Could you please explain how the regulations of service providers under the Prevention of Electronic Crimes Act are compatible with the freedom of expression under the covenant? Thank you, Madam Chairperson.
Thank you, sir. The floor is now for Madam Cleveland. You have the floor.
Thank you, Madam Chair. And I would like to thank the delegation for providing information, helpful information in response to some of my questions from this morning, particularly regarding the procedures for the exit control list. However, I would note that a large number of my questions went unanswered. And in that regard, I want to note that my questions and those of my colleagues seek information either that we previously requested from the state party, which was not provided in the written responses, or seeks clarification of the information that you did provide the committee in light of information that we are provided by civil society. The dialogue creates an opportunity for you to help clarify the committee's understanding of the situation in your country. Now, a substantial part of the response to my questions involved rereading full paragraphs of the written reply to the list of issues that had previously been provided to the committee by the state party. We obviously had already read the reply to the list of issues, and indeed it was the basis for a number of my questions. And so in that regard, my questions have not been answered, and I do hope that, as indicated, you will be able to provide that information in writing. Now, my questions for this afternoon involve issue 24 and issue 25 relating to defamation, freedom of expression, and freedom of association. With respect to paragraph 24 of the list of issues, we asked for information regarding your plans to decriminalize defamation, as well as cases that have been brought under the criminal defamation law, and we did not receive a response in that regard, so I would like to reiterate that request. I would also specifically request, if this is easier, the number of cases in which journalists or members of the media have been criminally prosecuted for defamation, the number of convictions, and in particular, cases for defamation that have been prosecuted before the ATCs and any imprisonment imposed. In this regard, I would note that this committee has consistently indicated that defamation should be decriminalized, that criminal penalties for defamation in any event can only be imposed for the most serious crimes, and that imprisonment should never be a punishment for defamation. With respect to the Pakistan Electronic Media Regulatory Authority, we understand that the authority has a code of conduct that prohibits, among other things, criticism of the armed forces and any anti-national or anti-state attitudes against basic cultural values, morality, and good manners. Media NGOs report that the authority has suspended several media channels for varying durations in recent years, amounting to more than 20 such bans in the past 4 years, and that these suspensions include suspension of 4 programs relating to Ahmadis. My questions regarding the authority are, does the chairman of the authority have the authority to immediately shut down a media outlet? And what procedural safeguards and oversight do you have in place to ensure that the authority does not exercise its powers inconsistent with the principle of the right to freedom of expression and access to information. Finally, under this issue is the issue of violence against human rights defenders, journalists, and lawyers. We're disturbed by the high rate of incidents of violence, disappearance, and killings of journalists, human rights defenders, and lawyers, and the low rate of prosecutions. One NGO has recorded 73 instances of journalists or members of the media being killed since 2002, with only 5 convictions for such a murder. Now, your reply, I appreciate and note, acknowledges such attacks and indicates that you have established a hotline, a post-injury compensation mechanism, and life insurance for victims. But with respect to violence committed against these groups by private actors, what additional measures, in addition to those you mention, are you pursuing to ensure the right to life and personal security for journalists and social activists? What protective measures are you taking, as well as measures to ensure accountability? Although your reply to the list of issues and your opening statement yesterday attributed such acts to terrorists, eyewitness reports have also reported the involvement of security, intelligence, and law enforcement personnel in some such incidents. Can you provide us with information regarding the measures you have taken to investigate allegations of the involvement of state forces in attacks on journalists, lawyers, and human rights defenders, and the measures you have taken to prosecute and punish those responsible? Turning to freedom of assembly and association, this asked for information about a number of issues, most of which were not addressed in your reply to the list of issues. And so I will largely reiterate the questions in the issue. We asked for information regarding the specific conditions that need to be met in order for a public assembly to be authorized, and for information on how many protests have been forbidden by a magistrate and on the procedures for appealing a magistrate's decision. So here I would reiterate the request for information regarding what restrictions are in place, what requirements must be met in order for a public assembly to be held, who issues the approval, and what is the basis for challenging a denial. We asked you to specify who is captured by the provision for being in the service of Pakistan, which precludes a person from the right to be a member of a political party. We asked for information regarding the number of political parties that have been found by the Supreme Court to operate in a manner prejudicial to the sovereignty or integrity of Pakistan, and any penalties imposed, as well as information regarding registration of trade unions and international NGOs. With respect to trade unions, we are advised that you do not allow the registration of trade unions unless the union includes at least 75% of all workmen actually engaged in the industry. And I would welcome information on the reason for this restriction and how many trade unions have been denied registration on this grounds. With respect to registration of international NGOs, Amnesty International reports that in 2015, your government announced a new policy giving broad powers to the Ministry of the Interior to review the registration of NGOs, international NGOs, based on funding sources and the nature of their work. A number of NGOs have been reportedly barred from operating in Pakistan on this grounds, including Save the Children, and a number of others have not secured official status. So can you provide us with information to clarify the policies that were announced in 2015? What is required for an NGO to become duly registered? And what are the consequences of failing to register? And how many registrations have been canceled or denied, and on what grounds? And that concludes my questions. Thank you.
Thank you, Madam Cleveland. Madam Brent Scarish, you have the floor.
Thank you, Madam Chair. I would also like to thank the distinguished delegation for the answers provided to some of my questions, and also for the willingness to provide additional answers and specific ones in writing. I will only note, therefore, in this follow-up that there was no comment, indeed, on the questions concerning the definition of torture in legislation. I will turn to my two questions this afternoon. There are issues 26 and 29 on right to marriage and family and right to participate in public affairs. So on issue 26, the committee appreciates the information provided in the state parties' replies that indicates several legislative initiatives to address the issue of child marriage, including at the provincial level. From the information provided, it appears that several laws adopted, the Sindh Child Marriage Restraint Act, and proposed, for instance, in Balochistan and Gilgit-Baltistan, set the minimum legal age at 18 for both boys and girls equally. Could you please update the committee on the progress made on the adoption of the proposed legislation that is mentioned in the replies? In contrast to these cases, the Punjab Marriage Restraint Amendment Bill of 2015 includes still the differentiated legal age for marriage as 18 for boys and 16 for girls. Could you please provide information on whether legislation in other provinces and territories still includes a gender differentiated minimum marriage age? And are measures planned to amend the Punjabi legislation to ensure equal treatment of boys and girls in relation to marriage as required under Covenant Article 23(4)? We have also noted that the already mentioned today Khyber Pakhtunkhwa Elimination of Customs of Khag Act. I think you will appreciate my gradually improving pronunciation. I have a ways to go still, but from 2013, and also the assurances that it is being implemented. But could you please provide additional specific information on how this implementation is taking place and how it is monitored? Have there been complaints and cases before courts based on this legislation? And what are the outcomes of such cases? Does the government monitor the actual situation on the ground regarding this custom and other types of forced marriages, including follow-up to the allegations of kidnappings, forced conversions, and forced marriages reportedly still widespread, especially in Sindh? Could you provide statistical information in writing, if need be, on the number of such marriages and the trends over time? And does such data indicate that legislation prohibiting such practices is having an effect in eradicating the customs? What non-legislative measures have been adopted and are planned in addition to the awareness raising regarding the disadvantages of child marriage as a regular part of provinces' human rights department's work, which is already reported in the state parties' replies? In addition, could you please provide specific information on the number of suicides relating to forced and child marriages, including of girls belonging to religious and ethnic minorities? And also please inform the committee on measures at the national and provincial level to prevent such suicides. I come now to issue number 29, right to take part in public affairs. The committee appreciates the information provided by the state party on the constitutionally guaranteed quotas and reserved seats for women and minorities in legislatures, both at the national and provincial levels, as well as the reserved seats at the local level for women, and also the additional information on participation already provided in this morning's session as well. The mention of special measures taken in order to promote the participation of women in voting are also well noted, including voter education and the collection of voter data disaggregated by gender, and recruitment of women to the Election Commission, which we understand saw its first woman member indeed last year. In view of information provided to the committee of places where women were prevented from participation in elections on 7th of May 2015, such as the 53,000 registered women voters in Lower Dir Khyber Pakhtunkhwa province, as well as reports indicating that it was discovered last year that over 11 million women voters were missing from the revised voters list, mostly we understand because they were not provided with a computerized national identity card. It was of particular interest to receive the information provided orally yesterday of the requirement to have at least 10% women voter participation in order for elections to be deemed valid, reported as a special measure adopted for areas of Pakistan where women are otherwise hindered from casting their vote, despite legal entitlement to do so. From information the state party provided, it emerges that the declaration of the annulment of the Lower Dir elections was made by the Election Commission and was upheld by the Supreme Court. Other reports indicate that this led to the draft election bill in 2017 that includes indeed a provision on nullifying elections in constituencies where less than 5 or 10% of voters were women. Could the distinguished delegation provide additional information on whether this election bill has been adopted and what the threshold of women participation in the final version of the bill actually is? In addition to these efforts with regard to participation in elections and elected bodies, the question of adequate participation in public affairs also includes executive and administrative bodies, including also law enforcement and the judiciary. The committee has received information that women in the police services represent less than 1% and that they are seriously underrepresented in the judiciary, especially in higher courts, where only 7 out of 130 judges in the Supreme Court and provincial higher courts combined are women. Could you please comment and indicate any positive measures taken or planned in order to address this inadequate representation? The committee has also noted information regarding the quotas and reserved seats for minorities in elected bodies at different levels and appreciates also the specific information provided by the state party regarding the set quotas. At the same time, the committee notes that the state party reports in its reply to questions on the list of issues concerning illiteracy, language barriers, poverty, and impediments to freedom of movement that there are no barriers on political participation, while ensuring the right to effective participation of minorities also entails ensuring that such participation can take place on an equal footing with other members of society, and thus often implies adopting special measures, such as providing election-related information in minority languages, including in areas of mixed populations. According to reports available to the committee, we have also noted that there was no minority representative on the Electoral Reform Commission, which last year was elaborating the proposed changes, including with regard to enhancing women's participation. Could the distinguished delegation please inform us whether there are any other special measures than the reserved seats taken with regard to minority participation? In terms of participation in the executive and civil service, we also take note of the 5% quota for minorities for jobs in the federal services that was mentioned earlier today. Are there mechanisms in place to monitor such representation? And could you please provide specific data on participation, including also in law enforcement and the judiciary? Several issues of concern regarding minority participation have been brought to the attention of this committee. CERD, also in the concluding observations in October 2016, expressed concern over the persistently narrow interpretation of the concept of minorities exclusively consisting of religious minorities and the absence of disaggregated data. Is data collected that would permit assessing the effectiveness of participation of ethnic and religious minorities in public affairs, including in elections, in elected bodies, in executive bodies, as well including the law enforcement and judiciary? An issue of particular concern for CERD was also the lack of identity documents of gypsies, Roma. Could the state party comment on this finding and explain how this affects their ability to participate in elections and other aspects of public affairs? Are measures planned to address shortcomings in this regard? Finally, the list of issues included requests for information on the reasons for the reported requirement that Ahmadis register on a separate voting list, since their names had been removed from the electoral list by the Election Commission in the 2013 elections. But since this issue was not yet addressed by the state party, could the distinguished delegation please comment this situation? What measures are put in place to ensure respect for the right to effective participation in elections by Ahmadis? Thank you very much.
Thank you, Madam. Mr. De Fruffil, you have the floor.
Merci beaucoup.
Thank you very much, Madam Chairperson. I will start out by raising the follow-up to the questions put earlier and tying in with what my colleague said, Ms. Cleveland, on the content of the reprise provided by the state party, which sometimes tend to refer to the report drawn up by the state party that the members of the committee know like the back of their hands almost. And so I would ask the delegation in subsequent responses to go above and beyond the report and to provide additional responses. Just a comment on the follow-up and a question that was broached by my colleague Mr. Iwasawa on the issue of enforced disappearances. I was quite struck and in fact shocked by some of the explanations provided on the issue of enforced disappearances in Pakistan, and particularly the assertion that these are voluntary disappearances. And the expression in English that's used is go to dark, I believe, says the speaker. And of course, this doesn't pay justice to the victims of enforced disappearances. These are people that have been removed from the protection of the law by state agents or by their families. And I would remind you that the committee believes that suffering inflicted upon families is equivalent to a violation of Article 7 of the Covenant. And as far as I know, this wasn't the stance adopted by Pakistan thus far, hence the fact I am so shocked and amazed that by the responses given, because Pakistan acknowledges that there's a problem of enforced disappearance, not a problem of voluntary disappearances, a problem of enforced disappearance. In other words, a problem linked to persons that are deprived of their liberty by state agents or persons who control them, and the family members are denied a response as to the whereabouts of the person, so they are removed from the protection of the law. There's a commission which was mentioned by the delegation. It's a commission on enforced disappearances. It isn't a commission called the Commission on Missing Persons. It's on enforced disappearances. So the name of the commission itself is a recognition of the problem of enforced disappearances in Pakistan. Furthermore, on several occasions, the Supreme Court has acknowledged the involvement of state agents in acts of enforced disappearances, particularly in its ordinance for provisional measures in the Balochistan Law and Order Act of 2012, where it cited the overwhelming proof of the involvement of the Frontier Corps of the abduction of persons in Balochistan, and then in 2013, Maobacha case, where the court stated that 35 people had been abducted in 2011 by the army, and the army hasn't investigated the 28 of the whereabouts of these people. So the Supreme Court condemned this in the firmest terms and described this as a case of enforced disappearance. And this is the reason why I was somewhat amazed by this business of voluntary disappearance, or people who suddenly disappear. Now, on the Commission of Inquiry, it has undertaken very significant work, but I believe that all of the bodies who focused on its work state that it doesn't have enough resources and it doesn't have enough power. Therefore, its powers would need to be strengthened. And I would like to ask the delegation if you have thought about strengthening the powers and resources of this Commission on Enforced Disappearances. Furthermore, my colleague Mr. Iwasawa raised the issue of impunity. As far as we know today, no state agent has been criminally convicted on the grounds of enforced disappearance and impunity. Could you give us some information about that? And we would be grateful if the delegation could provide specific information on the status of the inquiries on specific cases, recent cases of enforced disappearance that have been raised by my colleague, Mr. Iwasawa. Madam Chair, I'll come back to my questions for this afternoon. That is to say, issues 27 and 30. On issue 27, this has to do with children. First of all, the registration of children. Now, we welcome the efforts undertaken by the State Party to undertake birth registration, including the establishment of a mobile unit and efforts aimed at protecting refugee children. At the same time, the figures available, and the delegation will confirm them, state that only 30% of children are registered at birth, with a registration rate that is the lowest in the country in Balochistan and in Fatah. We would like to draw the delegation's attention to the recommendation issued by the CRC in its concluding observation, paragraph 29, and we would ask what measures have been envisioned by the State Party to implement those recommendations. As to child labour and exploitation of children, it is something quite positive that you have adopted the optional protocol on the sale, child prostitution and child pornography and child prostitution. And in several provinces, measures have been adopted on the rights of the child. And a number of laws have also been adopted on the protection of children. However, the devolution of the power to protect to the provinces, isn't this a problem when it comes to coordination? This is an issue that is very often raised. When it comes to labour, what measures have been taken by the state to develop inspections that are still very rare, particularly the sexual exploitation of children. What measures have been taken to facilitate the reporting of abuse, punishing the perpetrators and combating the stigmatization of victims? Lastly, what projects or bills do the state have with respect to a minimum age of child labour that are not in line with international standards? And here I'd like to go back to a recommendation on street children. There was a recommendation to set up an overall strategy to combat this phenomenon. Turning now to issue 30, which has to do with the dissemination of the Covenant and the preparation of the report. As to the dissemination of the Covenant, positive measures have been set out in the State Party report, and that is the institutionalization of drafting reports to uphold and implement the recommendations of the Human Rights Committee. You have set up a provincial cell to monitor treaties and a national cell. And this is indeed in line with the recommendations issued in order to set up national mechanisms to draft reports and follow up on recommendations. Now, a question I have for you in this respect is whether these provincial and national cells also are responsible for the follow-up of the recommendations of the treaty bodies, in particular the recommendations of our committee. With respect to the participation in drafting the report, here I was somewhat perplexed because in paragraph 37 of the report, the State Party says that a number of in-depth consultations were organised nationwide and at the provincial level. But credible sources furthermore say that civil society was not consulted. Only members of the National Commission were consulted. Could you tell us a little bit more about this consultation mechanism involving civil society and also the methods used to select the organisations and the individuals, particularly academics, who were involved in this process? And could you explain the perspective of some organisations who weren't sufficiently involved? Now, on the lack of participation of the National Commission, I would here revert to the independence of the Commission. At the beginning of this dialogue, I said that I had a theory on how things appear, and I'm not quite convinced by the arguments provided that the Commission cannot provide its own overview or its own viewpoint of the National Commission, and therefore the Commission would appear not to be independent. Perhaps I'm mistaken here, but we have two facts. And I said this at the outset of the dialogue. The president of this commission wasn't able to travel to Geneva to meet with committee members. This may be an internal problem, but the members of the commission, according to the allegations received, are part of the State Party delegation, and all of this simply reinforces our doubts. This commission cannot submit a report to the committee independently of the State Party report, even though the Paris principles allow national human rights commissions to cooperate with the United Nations. Now, the delegation have said that the mandate of the Commission is limited in that respect, and if that is the case, what does the State Party intend to do? Does it intend to amend this mandate so that it can rectify the harmful effects of the international activities of the Convention, which mean that it is not in line with the Paris principles? Thank you very much, Madam Chair.
Thank you, Mr. de Fourfield. There are no other requests for the floor. Mr. Hines, you have the floor.
Chairperson, And I would like to say that we benefited greatly from the answers already given. We have 3 meetings with this particular state party, which I find it to be very useful. And thank you very much for the dialogue that we have. I want to raise 3 issues. I'm concerned that there may be some misunderstandings, and we obviously want to avoid a situation where there's a strawman that is put up and then that strawman is dismantled. And what I mean with that is that approaches are attributed to the Human Rights Committee or to the Covenant that may not really be the position of the Covenant or the committee. In the first place, on the death penalty, the comment was made that the Human Rights Committee seems concerned about the rights of perpetrators and not those who perish for example, in attacks. And I want to emphasize that the committee has insisted in many occasions, as does the Covenant, on the duty to protect on states. In other words, to take effective counterterrorism measures. What the committee does is to say this should be done within certain frameworks, in the case of the death penalty, within certain safeguards. The death penalty as such is not in itself outside the possibility of what is permissible under international human rights. But there are certain procedural and substantive safeguards, and that is what the committee insists on. And I think in that context then, when there are broad statements made, categorical statements, that no juveniles have been executed or no mentally disabled people have been executed, but there are clear and well-known examples to the contrary that we then mention, but that is not disputed, one becomes concerned about whether those norms are in fact accepted. So I think it's important that in this constructive dialogue, that if something like that has happened, that a juvenile was executed or a mentally disabled person, that is part of what we discuss, and that there are steps taken to ensure that these norms are secured in the future. The second issue is the one of disappearances, where the impression may have been created that the state party requires accountability for every person who disappears in any country. And that's an impossible task, and of course that cannot be expected. But I don't think that is what the Human Rights Committee expects. Those disappearances that take within the control of the state, that is where we do ask for some kind of domestic accountability. And then if there are particular cases that we raise, it reassures the norm if we get responses to those particular cases. So in our list of issues, we raised the case of Mr. Muhammad Shah, and my colleague, Mr. Iwasawa, raised that issue again twice in the meeting. The Supreme Court decision concerning disappearances and the direct orders of the Supreme Court given in that 2013 case, but we haven't received a response to that. And I think perhaps part of the issue that we discussed earlier about making sure that we make the best use of our limited time is that it is helpful if we do get responses to those questions and we don't need to repeat the very specific questions. The last issue I want to raise is, it's more recently come to my attention, the case of Mr. Muhammad Iqbal, not the Muhammad Iqbal that was mentioned earlier, but the person who was, in 1999, was arrested at an age of 17 and was then tried, prosecuted, and convicted to death. His age was confirmed by ossification tests and also by his school leaving certificate. The trial court accepted this evidence, but nevertheless condemned him to death. And I believe he's now in the last stages, about to be executed. His case is currently pending for possible clemency, and that brings one back to the issue we raised earlier about the clemency possibility. And may I point out that this may be a good case if one talks about clemency procedure actually being implemented, that this may be a good case in which one then makes sure that the safeguards that people under the age of 18 at the time of the commission of the crime are not executed, that clemency for Mr. Muhammad Iqbal may be indeed an appropriate use of that clemency possibility. I thank you very much.
Thank you, Mr. Hines. Mr. Musa, you have the floor.
Thank you very much, Chair. And this is my first time to take the floor in the currency of this distinguished delegation from the land of Malala. You are very welcome. You have indicated that the state, at its discretion, can provide a lawyer to an indigent accused person being tried under the court-martial system. I would like to get some clarification. But you went ahead to say that when this is done, the government pays for that. I was wondering whether it's just discretionary or whether it is a guarantee that is within your law to provide counsel to an indigent person, regardless of whether it is the regular courts or the court-martial. On enforced disappearance, after my colleague, Mr. De Fruville, I just have little to add, but I want to say that this is a very serious thing, and it should never be reduced to voluntary disappearance for a person who is older, who is an adult, for whatever reasons that they may decide to take leave of their known places of abode. It is enforced, and it can be problematic, and would have preferred to get more information regarding this. This is more serious than what seems to have been relayed. On blasphemy, this can be very problematic because quite often, especially in the provinces, where you are not allowed to proffer evidence because that would be replicating the whole thing. I mean, what is to stop a person from raising a case of blasphemy against a person if I'm fed up with my neighbor and you just say, hey, I had her talking blasphemous things, and we know we have heard, and just quoting from the honorable delegation that we can get these things on television and the internet. Yes, we have been good students of that, and we have seen things on the internet and in the media where people have been actually stoned to death because of these things by mob action. I have an example here of Mashal Khan, a Muslim student at the University of Abu Wal Khan, who was killed by an angry mob in the presence of authorities. And that has not, that doesn't go well with the democratic credentials that Pakistan has, and which you have so much endeavored to tell this committee about. At every turn, you have indicated that indeed Pakistan is a democratic country, which we applaud. But this particular case has been very problematic, and we would like to have some more information, and indeed many other cases, but I will leave it at that, and hope to get specific reaction to this, if not in the oral, certainly in the written responses. I thank you.
Thank you, Mr. Musa. And now I think we can have we have a break. We'll give the delegation 15 minutes to organize itself, and see you in 50 minutes. Thank you. okay, let's resume the meeting. Mr. Excellency, the floor is yours to give some answers to the questions. Thank you.
Thank you very much. I would like to give the floor to Ambassador, and he will respond.
Thank you, sir. We've had many more questions again, and we welcome the observations and the comments of the esteemed members of the committee. And of course, in the spirit of having a positive discourse, and that is precisely why the delegation is here, and that is why the government of Pakistan is fully engaged with this very important committee. We see this as a positive interaction as opposed to being simply an adversarial inquisition type format. So in that spirit, we would like to move forward. We will be addressing some of the questions that have been raised in the last round. But before I come to that, I would also like to say Pakistan, we're a delegation. We are speaking from the land of 5-year-old Khala. We are speaking from the land of 14-year-old Etazaz, the schoolboy, people whose names are never mentioned in these hallowed halls. So many other children like this. This is the land that we come from, and this is where the delegation is coming from in our positive engagement with the esteemed members of the committee. Firstly, I would also like to touch upon the question of rereading some of the extracts that were submitted before. We feel that some of the rereading was required because the same questions were asked again. And therefore, we had provided the answers, and the answers were there, but we will still try in our written responses to further clarify, as has been the request here. Now, on one particular issue regarding this, there was talk about having, and I quote, eyewitness reports. Fair enough. But for our concerned authorities to fully examine that particular allegation, what would be helpful for us would be the identification of the eyewitnesses, because otherwise it would be yet another anonymous, non-verifiable allegation. And what this methodology does is that it places the cart before the horse, and it makes the guilty prove himself innocent. In our context, the innocent should be innocent until proven guilty. So this is one aspect we wanted to highlight. Again, on the commission, when I was referring to the commission, we were talking about the commission of inquiry on enforced disappearances. And I wanted to make that clear. And in the context of, there was a discussion and some comments about voluntary disappearances. Really, no one really knows when a person takes the decision to disappear from their homes. I'm not saying, and the delegation is certainly not saying that is all of it, but there's certainly an aspect of this. And until the authorities have established that specific commission, the Commission of Inquiry on Enforced Disappearances, has determined the nature of that person's disappearance or missing from home or going dark, it remains in that realm that no one truly knows. And really, honestly, there's no need to be amazed about what we had said earlier on, because quite frankly, people who leave their homes and disappear from their homes, it's a global phenomenon. It's not just, it's everywhere. People, teenagers all over the world just disappear and then they show up again. So just to say that to have a blanket dismissal, or it's quite frankly, we're the ones who are a little bit amazed that this fact is not acknowledged by some members of the committee. Now, having said that, I would like to, talking about the rereading, I will engage in another set of rereading, unfortunately, because the issue of trade unions was already covered about a month ago in the International Covenant of Economic, Social and Cultural Rights. We had a specific individual that was here, a senior official, a woman official, who came and read all of this and had informed the that particular committee. But again, if this committee so requires, I would like to reread that for this committee as well. So, in terms of the freedom of association and collective bargaining, the Ministry of Overseas Pakistanis and Human Rights Development, Human Resources Development, are conducting a national and provincial consultations on the implementation of the core labour standards to identify the gaps in the implementation of the relevant labour laws and strengthen the capacity of provincial tripartite consultative committees to facilitate delivery of services under the law. The ILO and the Pakistan Workers' Federation supported the first ever capacity building workshop for the trade unions on Azad Jammu and Kashmir area with a focus, and I would highlight, a focus on the freedom of association and collective bargaining to be a part of that process. Now, we can, there's a lot here. I will read certain aspects of this, and we can share this with this committee in our written responses. But under Section 2 of the Industrial Relations Act of 2012, worker and workman means person not falling within the definition of employer who is employed, including employment as a supervisor or an apprentice in an establishment or an industry for hire or reward, either directly or through a contractor, whether the terms of employment are express or implied, and for the purposes of proceeding under this Act, in relation to an industrial dispute, includes a person who has been dismissed, discharged, retrenched, laid off, or otherwise removed from employment. Now, this goes on, it's quite detailed, but we will submit this as part of our written response. The Registrar Trade Unions, the RTU, registers the trade unions in the trans-provincial establishment and establishments which are in Islamabad, which fulfill the requirements mentioned in Section 7 and Section 8 of the IRA of 2012, as well as the regulation contained in the NIRC regulations of 2016. The Registrar Trade Unions has not yet refused the registration of unions which have enlisted membership of those workers who are employees in the establishment through subcontractors. However, there are litigations pending in different courts challenging the status of workers who are members of unions on the ground that being the employees of a third-party contractor, subcontractor, cannot take part in the union activities of the establishment borrowed them. So, our provincial assemblies also have labour departments, and they are undertaking the requisite measures. I can talk about Khyber Pakhtunkhwa. There are no obstacles as to the registration of trade union of workers or employees. There is none. The workers and employers are free to join and free to register a trade union of them while observing the legal requirements. And as far as formation and registration of a trade union of workers engaged on contract or through a subcontractor, the law, the Khyber Pakhtunkhwa Industrial Relations Act of 2010, does not bar workers to form and register a trade union of them. So this is these laws are being repeated throughout our country by the provincial governments. So I won't really go into those details because it'll be another rereading of what we read at the last committee. But I will certainly sort of like to highlight the fact that this material has already been submitted, but we'll be happy to resubmit it. Now, moving on to the issue of blasphemy and the blasphemy law, and I will do a reading of this because this is a highly contentious and a highly misunderstood and a misquoted issue. And so I would say the blasphemy law was introduced during the British rule in South Asia. You're all aware of this. Such laws also exist in many countries. There are more than 20 European countries who currently have the blasphemy laws on their statutes. The government of Pakistan, however, is mindful of its responsibility to prevent the misuse or abuse of the blasphemy law, especially by those who wish to exploit it for personal gain or interest. The government takes any complaint of the blasphemy or complaint of misuse of blasphemy law with the utmost seriousness and continues to take legal, administrative, as well as policy measures to prevent its misuse. The laws aim at ensuring public order and harmony in society by seeking to prevent, and I repeat, prevent inter-religious discord and incitement to violence through hate speech. Blasphemy law in Pakistan is not discriminatory as it is based on respect for all religions. It deals with offenses against all religions and applies to Muslims and non-Muslims alike. In 2002, the esteemed committee members would like to note the Lahore High Court had prescribed that only a district or a session judge should sit at the bench hearing cases regarding blasphemy. Section 196 of the Code of Criminal Procedure of 1898 provides that no court shall take cognizance of any offence punishable under 295A, which is deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs, of the Pakistan Penal Code, unless a complaint is made by or under the authority from the federal government or the concerned provincial government. If prior permission is not obtained, a judge cannot take cognizance of a private complaint. So the Section 295 PPC covers all religious denominations, which suggests the blasphemy law is non-discriminatory. Section 211 of PPC states that a person intentionally initiates a false criminal case or puts false charges on any other person for an offence without lawful ground shall be punished with imprisonment of 2 years or fine or both. He or she may also be imprisoned for 7 years and fine if punishment for such falsely charged crime is death, imprisonment for life, or for 7 years or more. This is a significant deterrent against the initiation of false cases. Lately, it's also been witnessed that religious leaders are the first ones who condemn the acts of discrimination and incitement to hatred against religious minorities. For example, the Pakistan Ulama Council was one of the first to condemn the false accusation of 14-year-old Rimsha Masih, who was allegedly accused of blasphemy. Subsequently, on 14th of November 2012, the case against her was dismissed by the Islamabad High Court. The cleric of the masjid in Rimsha's area, who apparently tampered with evidence by desecrating the Holy Quran, was detained by the police and tried under the same blasphemy law, Section 295B. The judgment of the Supreme Court in the case of murder of the late Governor Salman Taseer on 8th October 2015 to restore the death sentence awarded by the Anti-Terrorism Court to Malik Muhammad Mumtaz Qadri is a historic judgment which clearly explores the judicial shield to protect the rights of the people. The Honorable Supreme Court decision mentions that there is no justification of a civilian or any individual not in that position of authority to decide to take the law into his or her own hands and kill the alleged offender.
Excuse me, Mr. De Vroeville?
My apologies, Chairperson, but the interpreter working towards French is saying that she can't keep up because the speaker is reading and reading very quickly indeed, and it's difficult for interpretation purposes.
J'ai pas entendu. Pas entendu. Microphone. Microphone.
An independent judiciary, free media, and vibrant civil society also provide effective safeguards against misuse of the blasphemy law. Courts have also ensured free and impartial trials, thus effectively protecting citizens' rights enshrined in the Constitution. There is also an effective process of appeal in case of conviction under the blasphemy law. If any accused is convicted and awarded capital punishment by Court of Sessions, the same is required to be confirmed by 2 judges of the High Court. Otherwise, it cannot be implemented. After the decision of the High Court, the convict has the remedy to appeal to the Supreme Court of Pakistan. If the apex court upholds the verdict of the High Court, a mercy petition can be submitted to the President of Pakistan, who, under Article 45 of the Constitution, can grant pardon, reprieve, and remit the sentence. In August 2016, the NCHR presented a comprehensive report to the Standing Committee on Human Rights of the Senate regarding introducing further possible checks to prevent the misuse of blasphemy law, and recommended procedural amendments to the Parliament in blasphemy law to prevent its misuse and misapplication. These recommendations are also being considered by the Parliament. Now, moving on to the Pakistan Penal Code, Section 295, it is, and I repeat, non-discriminatory in nature. It deals with offences against all religions and applies to Muslims and non-Muslims alike. In fact, the majority of cases registered under this section have been against Muslims. And let me repeat that. In the majority of cases registered under this section have been against Muslims. From 2007 to 2010, 253 persons have been convicted under the blasphemy law, out of which 244 were Muslim and only 9 were non-Muslim. In the case of Punjab, which is the largest province consisting of more than half the population of Pakistan, during 2011 to 2015, 1,296 cases were registered. Of these, only 48 cases were registered against non-Muslims by Muslims, whilst 1,201 cases were registered against Muslims, and the rest were registered against unknown persons. Hence, less than 4% cases were registered against non-Muslims. In the case of Balochistan, no case was registered on accusation of blasphemy. In case of Sindh, the second largest province of Pakistan, only 11 cases were registered. In the case of Khyber Pakhtunkhwa, only 19 cases were registered, and most of them were against Muslims. The recent statistics show that from the 1st of September 2015 to 30th of June 2016, nobody was killed in Punjab on allegation of blasphemy. 96 persons are under trial in blasphemy cases. 19 have been convicted, including 1 person who has been awarded a death sentence. No one has been awarded life imprisonment, and 18 others have received sentences of a shorter duration. Now, I would just come back to the question of Ahmadis. Regarding the Ahmadiyas, after the Second Amendment, Article 260, brackets 3 of 1974, in the Constitution of Pakistan, 1973, the Ahmadiyya community has been declared as a minority. The Ahmadiyas have, under Article 20 of the Constitution, all rights as citizens of Pakistan, including to profess their religious beliefs without discrimination. 13 publications, including a daily, weeklies, fortnightlies, and monthly bulletins, magazines, and newspapers, are brought out by the Ahmadi community. Now, turning to the issue of Mashal Khan, Firstly, as far as we know, the delegation is Mashal Khan was not an Ahmadi. But that does not change the seriousness of this crime. The government has taken serious notice of the murder of the young student, and I would like to update the committee on the latest situation. A total of 60 persons accused have been identified during the course of the investigation of the case, out of which 57 have been arrested and are in judicial lockup, while the remaining 3 accused are absconders. They've gone dark. They've disappeared. Out of the arrested accused, 12 are university employees. 1 is a lecturer of the lecturer of Government Degree College Mardan, 1 an outsider, and 43 university students. The principal accused, namely Imran, who allegedly who fired the pistol on Mashal Khan, has been arrested, and the weapon of offense has been recovered at his instance. He also confessed his guilt before the court. The report about matching of the recovered weapon of offense with empty cases recovered from the spot has been received in positive. 8 of the 8 accused have made confessional statements before the court, and 9 statements have been recorded under Section 164 CRPC, including the statement of Muhammad Iqbal, father of the deceased Mashal Khan. The JIT has also recommended departmental action against the university administration for their negligence and inefficiency of handling the situation. It has also been recommended to conduct verification of the university employees to ascertain their character, method of recruitment, and educational qualifications. As per the investigation so far by the JIT, nothing with regard to the involvement in blasphemy has proven against Mashal Khan, deceased. The students, namely Zubair and Abdullah. The JIT finalized the investigation on 3rd of June 2017, and on 5th of June 2017, the SHO submitted the challan before the court through the public prosecutor. So this is as all of Pakistan knows, is a very sensitive case. It is a case that is being followed through by the courts. It is a case that even the Prime Minister had commented on. It is a case that had shaken the nation. But we believe in our judiciary, we believe in our due process of law, and we believe that justice will be served in the case of Mashal Khan and anybody else who has been wronged in this particular manner. So after these, I think this is the area that I was going to cover. I would like to now hand the floor over to Secretary of Human Rights. Thank you.
Thank you very much, everybody, for your time. Just going to address a few small questions, and then we can move on to a little bit of the bigger issues. Madam Cleveland, you asked about the police. I just want to tell you that in 1984, when I joined the civil service, we were 10% of the number of people that made up the civil service. And today, the exam that came out, just I think results were like about 4 or 5 months ago, the toppers were all women. And now women comprise 40% of the attendees at the Civil Services Academy. So that includes members of the Police Service of Pakistan and the District Administration, Foreign Affairs, etc. I'd also like to just mention that of the 1 million university students, 47 comprise women. In the medical schools, the women, this was regard to the women are the top medalists. We have been fortunate now that we have women in the police. Incidentally, one of the police ladies from the police was supposed to accompany us, but couldn't make it. We have women in the bomb disposal. We have women just recently have entered the firefighting force. So just to give you an idea of the stereotypes that are being broken. There was a question about the consultative process of the ICCPR, and I confirmed, Monsieur Fruvel had asked this, that yes, they were involved, and a consultative process were held both at the provincial and federal level. Then we had a question on the registration of INGOs. Of the registration of INGOs, 100 INGOs applied for registration. I understand 60 have been registered so far, and 40 are now in the process. Also, I'd like to get to the question that was asked by Mr. Haynes. I don't know if I'm pronouncing it right, but you had asked the question of Muhammad Iqbal and the issue of juvenile justice. What I'd like to bring to your notice is that it was on the intervention of the the National Commission on Human Rights that the execution of Iqbal has been stayed. Yes, it is certainly subject to review and the mercy petition on the discretion of the Honourable President. Furthermore, I'd like to say that in the present juvenile justice system, 2000, there are many steps at which the age of the offender can be ascertained. One at the time of arrest, the arrest certificate, which we call the Hulia form, which is the appearance form, statement under 161 CRPC, the entry in the police diary, which is known as Zimni in our language, statement under 164, recording of evidence, statement under section 340 and 342 of the CRPC, then appeal to the High Court, appeal to review petition to the Supreme Court, and then a pardon to the President of Pakistan. The issue of Shafqat Hussain had exhausted most of all the avenues open, and including a private investigation done by the Ministry of Interior also. What I would like to bring to your attention is that there are issues with juvenile offenders. There's the issue of age determination, and there's the issue of the mental health of many accused persons. And the practice in the police in Pakistan is access to psychiatric care is limited. The Ministry of Human Rights just recently, I mentioned it yesterday, we've drafted a juvenile justice ordinance bill 2016, which when it comes will be 17, and this provides very, very clear mechanisms for the addressal of age, including self-determination. So if the accused, and this was put in during the debate in the Standing Committee of the National Assembly, if the accused actually says I'm underage, then the onus is upon the police to prove that he is not. We've also, this act also identifies a system of diversion. We have, within this act, there is a Juvenile Justice Committee comprising 4 members, a sessions judge, judicial magistrate, a district prosecutor, member of the bar, and a member from the Social Welfare Department. And the idea is that through diversion at the first step, the government can find a mechanism whereby offenders for minor crimes, or if they are younger than 16 for major crimes, will go through a process of diversion to do community service, to go to rehabilitation homes that will then be monitored by a proper advisory committee in this case. Furthermore, there are systems put now within this new law where the children will not be sent to, accused offenders will not be sent to police stations, but to observation homes, where a social welfare officer will be mandated to be present. And then they will be, also as a follow-up step, there will be juvenile rehabilitation homes. The idea is that we're cognizant of issues that are taking place, and we're trying to find remedies to be able to address the issue of the rehabilitation of children, and to be able to ensure that they don't become hardened criminals and that they are able to be rehabilitated back into society. So the Juvenile Justice Act has been passed by the Standing Committee, will be presented to the Senate, and hopefully we should be able to see greater stringency in this regard. So that's one issue. I think that sums it up. Thank you.
So I would like to give the floor to Mr. Amir Khan. He will respond.
Minister, let me tell the respected committee members that freedom of expression is a fundamental human right which is preserved in the Constitution of Pakistan through Article 19. Also, Article 14 of the Constitution stipulates that dignity of man and privacy of home shall be inviolable. It is a hard-fought right by the people and our political leaders, and during their struggle for democracy, they have made immense sacrifices in order to attain this fundamental right. That is why we hold it very near and dear to our hearts. The Article 19 of our Constitution is critical in not only protecting the speech that a listener may approve of or agree, but also a speech that he may disagree with or even hate. The article thus recognizes that the freedom of expression comes with responsibilities, and thus it could be put to reasonable and proportionate restrictions permissible both under domestic and international human rights obligations. It is, in our view, essential in order to protect our basic rights and dignity of all our citizens and to differentiate between free speech and hate speech when it leads to incitement to violence. As highlighted earlier, combating terrorism has been our first and foremost priority. We know that terrorists utilize internet for insidious purposes, and it is particularly troubling when cyberspace becomes a conduit for extremist ideas fueling terrorism. In this regard, I would like to refer to the UN Security Council's Resolution 2178, which took note of the increased use of information technology by various terrorist groups across the globe. All over the world, governments have different rules and regulations in order to use and regulate digital information with a view to combat terrorism. Several Western governments, we believe, they gather the largest haystacks of data in order to trace terrorists and criminals. Pakistan's cybercrime bill complements the efforts of our law enforcement agencies to combat terrorism. It allows only targeted surveillance of digital information and cyber data, which is, in our view, essential for enhancing internal security and to timely thwart terrorist activities. Respected member of the committee from Japan has referred to the lack of transparency during the legislative process of the Pakistan's Prevention of Electronic Crimes Act of 2016. Let me assure the committee members that we followed the process with multi-stakeholder discussions, and it was elaborate, broad-based, multi-stakeholder. Let me give you a timeline how we attained this overall broad-based consensus in our government. The PECA was prepared by the Ministry of Information Technology of Pakistan and in consultation with all stakeholders, including representative associations of telecom and IT sectors, civil society. As part of the parliamentary process, a standing committee, including members of the opposition parties, was set up to review it at various stages in light of the Constitution of Pakistan and the Convention of Cybercrimes, that is the Budapest Convention, and other national laws. In order to hear the concerns and reservations from certain quarters, the Standing Committee conducted a public hearing in which stakeholders as well as members of NGOs participated. They were asked to provide their comments in writing. However, no substantive written proposals were provided by them. Only vague and generalized objections were made. In order to give one more chance and another opportunity to stakeholders and NGOs, the Standing Committee formulated yet another bipartisan subcommittee which considered inputs, comments received from the general public through media or directly, and to give its recommendations on it. The subcommittee gathered inputs and comments from all quarters, including some proposed amendments in the PECA made by a joint action committee comprising of a group of NGOs and some stakeholders. In its meetings, the subcommittee also heard the lawyer representing the stakeholders. the subcommittee reviewed the PECA clause by clause in light of the inputs received from various quarters and recommended a number of amendments in the PECA besides proposing insertion of some new sections. The report of the subcommittee analyzing inputs received from all stakeholders was finally presented to the Standing Committee. The Standing Committee was apprised about the recommendations of the subcommittee by its convener, and after detailed deliberations thereon, the recommendations of the subcommittee, with certain changes proposed by one member of the opposition, were approved on 17th of September 2015. The Standing Committee also directed the Ministry of IT to make available a copy of the modified PECA bill on its website, which was accordingly done. So there was this process for sure which was followed, and we are quite confident that all multi-stakeholders, all stakeholders were discussed with and were under confidence in order to reach a broad-based consensus on this important issue. Now, the PECA, that is the cybercrime bill, for sure contains a system of checks and balances in order to avoid any misuses, like any other law. Most of the offences under the Act are non-cognizable, except offences relating to child pornography and cyber terrorism. What does it mean? It means that the investigation agency cannot proceed against any person for investigation of these offences without the approval of the court. Moreover, special courts are to be designated under the Act in consultation with the Chief Justices of the respective High Courts. While on one hand, we hear comments that punishments provided under the PECA do not meet the proportionality requirement of Article 19 of ICCPR, on the other hand, we have been consistently told that the punishments provided are lenient and therefore do not provide appropriate deterrence. So the government had to take a decision, and the government now is of the view that the punishments under the PECA are rational. The bill provides discretion to courts to either impose pecuniary penalties or imprisonment or both. In some offences, the first violation does not entail any imprisonment at all. Just to give you an overview, Sections 3 and 4 on authorized access to information systems and on copying and transmitting data are completely in line with Articles 2, 4, 5 of the Budapest Convention. Section 9 on glorifying an offence and hate speech is completely in line with Article 20 of ICCPR. Section 10 specifically relates to cyber terrorism and comes into force only when hacking of a critical information system is committed with the intent to coerce, intimidate, overawe, or create a sense of fear, panic, or insecurity in the government or the public or a section of the public or community or sect, or create a sense of fear or insecurity in society, or advance religious, ethnic, or sectarian discord. So these particular provisions are necessary components to implement our national action plan to support our ongoing fight against terrorism. The definition of authorization provided under Section 2 of the bill covers authorization by law. Thus, if a whistleblower reveals any information of public importance that he was obliged to reveal by law, such activities shall not fall within the purview of Sections 3, 4, and 10. Now we come to Section 18. Section 18, we believe, is completely in line with Article 19 of ICCPR. It is meant to safeguard and respect the rights and dignity of others, national security, public order, public health, and morals. Besides, this provision only relates to false information, and fair criticism, opinion, or true assertions do not fall within the purview of this section. There has also been some reference to right to privacy. Now, in the PECA, the Cybercrime Act of Pakistan, any unauthorized access to a network of private data is declared as a criminal offense under the Act, which provides a complete legal framework for handling of any private data legally accessed by a service provider or a member of an investigation agency. The privacy of a user data and its integrity is given prime importance. And in order to ensure the same, the government of Pakistan has promulgated Fair Trial Act of 2013, which provides detailed procedure for sharing data with law enforcement agencies after fulfilling all legal requirements. In addition, the government is also working on formulating a special law for protection of personal data. Section 32 of the Act requires service providers to retain traffic data for a period of 1 year or such period as specified by PTA, that is the Pakistan Telecommunication Authority. Section 41 imposes an absolute obligation not only upon service providers, but also upon an authorized officer to ensure confidentiality of any material or data containing personal information about another person. Breach of this obligation to keep personal information confidential attracts imprisonment for a term which may extend up to 3 years or with fine up to 1 million Pakistani rupees. Section 42 of the Act governs the principles of international cooperation with any foreign government, networks, any foreign agency, or any international organization or agency for the purposes of investigation or proceedings concerning offenses inter alia relating to information systems, electronic communication or data, or for the collection of evidence through one of its agencies designated under the Act. Now, this provision has been incorporated and is very much in line with the International Cybercrime Convention, that is the Budapest Convention. And it does not require any judicial authorization or oversight for its implementation. Section 22 is on spamming, and it is exactly there to protect the privacy of an individual in line with Article 17 of ICCPR. Now let me come to the Pakistan Telecommunication Authority, because the distinguished expert referred to the broad powers and sort of carte blanche. I beg to differ with that. Section 34 of the Act deals with the power to manage online information. It does not give any such powers to an authorized officer of the Pakistan Telecommunication Authority. The provision in this section is in line with Article 19 of the Constitution of Pakistan, and it further ensures that the PTA, the Pakistan Telecommunication Authority, develops the proper legal framework for performing this function strictly in accordance with the Constitution. Political comments or criticism of the government cannot be blocked under this provision. In the Act, the power to block or remove any terrorism-related propaganda, hate speech is given to Pakistan Telecommunication Authority. And what is this authority? This is a statutory regulatory body that performs its functions under strict judicial scrutiny. Moreover, if any person is aggrieved by any order of PTA, he or she can file an appeal in the High Court or a tribunal constituted under Pakistan Telecommunication Reorganization Act of 1996. An aggrieved person may also file a writ petition under Article 199 of the Constitution before the High Court against any order passed by the PTA under Section 34 of the Act. Similar powers are provided to the central government and law enforcement agencies in other countries as well, which may exercise such powers without any judicial scrutiny. The Supreme Court of Pakistan has also directed PTA to check unlawful content on the internet. The Islamabad High Court, via its order dated 20th of January 2015, has directed PTA to undertake actions in respect of objectionable material accessible through internet. Thus, Section 34 of the PECA aims at streamlining the powers of PTA and ensuring their exercise in a judicious and fair manner. Lastly, let me inform the honorable committee members that the Prime Minister of Pakistan has constituted a high-level inter-ministerial committee in order to oversee the smooth implementation and enforcement of Pakistan's Prevention of Electronic Crimes Act, PECA of 2016. Thank you very much.
Thank you very much. I would like to give the floor to Ms. Saima, so she will respond the rest of questions.
Thank you, Honorable Minister, distinguished members of the committee and chair of the committee. I would like to comment on some of the questions relating to freedom of assembly, of which some of the points have been shared by my distinguished colleagues already. Pakistan today is a thriving democracy, and a democracy in a country cannot thrive without freedom of assembly and association, which is guaranteed by Article 16 and 17 of Constitution of Pakistan. Regarding restrictions, if any, on the freedom of assembly and association, yes, there are restrictions in accordance with law, as is the case with other countries. And those restrictions are only when a peaceful assembly turns into a violent assembly. Only then the continuation of that peaceful that assembly would be checked and would be brought into within the domain of law. For that, a principle of necessity and principle of proportionality would always be kept in mind and would be applied, and there are provisions under Criminal Procedure Code and Pakistan Penal Code to deal with that. There have been certain instances in which exercise of right of freedom of assembly and association was temporarily prevented only on only one ground, and which is the reality of today, that in many areas of Pakistan, due to terrorism, there have been certain terrorist threats which prevented the law enforcement agencies to inform the organizers of the assembly that they might face certain threats. However, in those cases, those political parties and trade unions and organizers of the assemblies have gone to the court, and decisions have been given in their favor. And there are several judgments, for instance, in case of Islamabad High Court, where whenever the authorities stated that there were certain threats and assemblies could not be held, but Islamabad High Court allowed the assemblies to continue. Just to quote an example, that in Islamabad, which is the federal capital of Pakistan, just in front of the parliament of Pakistan, there was a 126-day-long peaceful protest, and it was allowed. There were no restrictions. Regarding political parties, whether there are certain restrictions and bars on them, Political Parties Act of 2002 regulates the registration of political parties. And Election Commission of Pakistan, which is an independent body, regulates the political participation, and it has certain rules and regulations how to register a political party. And no political party has been barred as long as it fulfills all the requirements and procedures which are required by the laws and regulations of the country, which are quite liberal, because we have more than 50 political parties currently operational in the country. As my colleague has shared some of the figures regarding NGO registration, I would like to just make a small comment that NGO regulation policy, the aim of the policy was to streamline and facilitate the NGO regulation procedure, not to restrict the activities of the NGOs. Because in the past, the NGO regulation procedure was slightly cumbersome, and NGOs face certain problems while registering, and it was difficult to keep a track. With this new policy in place, the government authorities are aware of the activities of NGOs, and they can facilitate them in terms of providing them necessary facilities wherever they work in different districts and different areas, and also can help them in providing security, because they know that where they're operating and which is the functional area that they're working in. And today, in this August room, presence of a number of NGOs from Pakistan demonstrates the fact that there are no restrictions whatsoever on either the registration or on the exercise of activities of NGOs. They are here to share their views, and they have already interacted with the committee. That demonstrate the vibrancy of our society and democratic nature of our social structure. Moving on to issue number 27 regarding the rights of children. Let me state at the outset that the government of Pakistan is fully committed to promote and protect rights of children, not because that we are a party to CRC, but rather because it is our moral and religious obligation. As party to the Convention of the Rights of the Child and two of its optional protocols, we are committed to the implementation of the Convention, and we take a serious note and thoroughly consider the concluding observations of the committee, which were made last year during the review of our 5th periodic report on Convention on the Rights of the Child. The committee acknowledged the will and the commitment of the government of Pakistan to protect and promote rights of children in the country, and also pointed out some of the challenges as well. I'll move on to the issue of birth registration. I would like to say that claims of only 30% birth registration unfortunately cannot be corroborated by facts on the grounds. And reasons for that I would share just very briefly a few of the measures, because we've shared those already in our responses to the list of issues. We have a National Database and Registration Authority, and birth registrations are done at Union Council level. For that, in collaboration with UNICEF, we have devised National Civil Registration Management System, and it is a computerized system through which births are registered. And it has access to all districts of the country, to all far-flung areas, including FATA and Balochistan. However, to ensure that every child born in the country is registered, awareness-raising campaigns have been launched. And recently, we have launched an innovative program in collaboration with one of the telecom providers, Telenor. Through their call center operators who are helping out, they've been trained to register births by just calling on the call center, and any family can register a birth. So this is the way to facilitate. In addition to that, NADRA has mobile units. Regarding those births which have not been registered in the past, recently we have held national census. And it was a comprehensive program which lasted for months. And those births, I'm sure, which have been missed or not accounted for, now we will have a comprehensive data of the demographics of different areas, the total population, the age, and everything. So we will have a complete holistic picture of anything that has been missed in the past. But certainly the birth registration rate is not 30% in the country. Moving on to sexual abuse and how victims are protected and what has been done for them. Last year, criminal law amendment bill was adopted, which covered the issue of sexual exploitation and sexual abuse of children in a comprehensive manner. Also, we have adopted in 2016 Prevention of Electronic Crime Bill, and its provision number 19 explicitly states that if sexual exploitation of children occurs due to online means and methods, there will be an imprisonment of 10 years and 10 million rupee fine. In addition to that, child protection centers have been established throughout the country to facilitate and rehabilitate those children who have been sexually abused, so that they can find shelter and security at one particular place and can have access to legal counsel as well. In order to ensure that the victims do not face further harassment, their identity is kept secret in cases of sexual abuse. Newspapers have been issued guidelines, and media persons are mindful of the fact that they're not going to reveal the identity of the individual which has faced sexual exploitation. Recently, the Parliament of Pakistan has adopted National Commission on the Rights of the Child Act. With the adoption of this act, child protection measures would be further strengthened, and this independent commission will further augment government's efforts to protect and promote rights of children. Previously, we had also national NCCWD and PCCWD to facilitate and protect rights of children. At the federal level, we have a Wafaki Muhtasib, and Wafaki Muhtasib has appointed a child commissioner both at federal and provincial level. Within the Wafaki Muhtasib and the provincial Muhtasibs, they've also set up child complaint cells in which children can go and complain regarding any threat, harassment, sexual abuse that they may face. Government of Pakistan, in collaboration with UNICEF, has also launched several campaigns regarding child abuse. Pakistan is also part of South Asia Initiative to End Violence Against Children, which also include the issue of sexual violence. And there have been several projects and several seminars and awareness-raising campaigns that have been held in collaboration with SEWAC and by Ministry of Human Rights. Moving on to the issue of child labor, we in our report as well as in our responses to the list of issues have shared a number of measures, laws and policies that have been introduced by the government of Pakistan to end the despicable practice of child labor, because it robs a child of not only human dignity but right to education as well. I would specifically focus on the question relating to inspections. I will give, due to paucity of time, only a few examples. Under the child labor at brick kilns ordinance 2016 of Punjab, 9,000 inspections have been carried out in almost a year. 850 FIRs have been registered, and 800 children have been recovered and rehabilitated through various programs and through various rehabilitation centers. They are being provided protection, education, stipends have been provided, microcredits have been provided to their families to ensure that they don't send their children into forced labor, or such practices can be avoided. Other inspections, for instance, in the ball industry of Sialkot, 7,500 children have been rehabilitated and they are receiving education, and they're being provided stipends. In the carpet weaving industry, 62,000 children have been rehabilitated, and they're being provided shelter, education, and all their basic needs are being fulfilled. In the surgical manufacturing industry, more than 1,200 children have been rehabilitated. These are just some of the examples that I wanted to share with the committee. There are many more figures that we have of various parts of the country, because a lot has been done to eliminate child labor from Pakistan, and the government is fully committed to do so. Regarding street children, recently, just last week, Child Protection Act has been passed to deal with the issue of street children, to provide them access to education, to facilitate their rehabilitation, to ensure their protection. And in the past, social welfare departments of various provinces, Ministry of Human Rights, and various civil society organizations have been dealing with this issue in a comprehensive manner, because no child should be deprived of the right to education, right to human dignity, and to all basic rights. These were some of the questions that were related to this, and I would like to give back the floor to Honorable Minister. Thank you.
Thank you, Simon. I would like to give the floor to Mrs. Shaista Pervez Malik, Member of National Assembly, Pakistan.
Thank you, Minister. Please allow me to tell the August Committee that women in Parliament, it's the highest in South Asia, the women in Parliament in Pakistan. The IPU listing puts Pakistan ahead of 25 industrialized countries. I'm highlighting this because the women in Parliament are making the laws to change ground realities, as in the police services. I repeat again, the work is in progress. This is incremental development, step by step. It's solid development. No point in having a showpiece only for show. We get elected, we change the laws, we change the society through legislation and through democracy. Now, what is the government doing to facilitate their participation and development? Gender and women development have been included in annual plan, 5-year plan and Vision 2025, which we have, which fully cover development initiatives related to women's status. Number of measures have been taken for improving women's gender status and public affairs participation. I will not repeat what I have earlier said, but amendment of inheritance law in Punjab to ensure ownership of land and assets to women has been put in place. To ensure women's participation in the electoral process, a gender cell in Election Commission of Pakistan is already working, and the commission is to take special measures to improve women voters' registration and to improve nationwide, increase the registration where it is low. And for that, the NGOs are working in close collaborations. We are having seminars, we are involving the local governments, we are involving the people of the community, the political participation, to have women have themselves registered as voters and to make them realize the importance of a vote. Provinces have special skill development programs with up to 35% quota for women. Providing daycare facilities for children of working women at workplace. This was a great hindrance where women could not work. A Centre for Social Entrepreneurship at a cost of rupees 178.43 million has been established by the Ministry of PD&R with particular focus on women's startups. And here I would just, for details, that there's a flagship program of BIS, that is Benazir Income Support Program, is providing cash grants to 5.5 million women in poor households to improve women empowerment. And this was launched in 2008, increased from 1.7 billion beneficiaries in 2008 to 5.4 million in 2013-14. Disbursement rose from 16 billion in 2008 to 96 billion in 2015-16 to 126 billion in 2017. This has affected life of 5.5 million women. And it is the amount has been increased from rupees 1,000 to 1,500. Self-registry started, whereby women can register themselves through computer-assisted personal interviewing. Then another very important program which came under this Benazir Income Support was Wasila-e-Taaleem. It's a program to encourage BIS families to send kids to school. A cash is given to them. Over 1.3 million children enrolled and rupees 3 billion disbursed in this program so that they can educate their children. Now, property and marital rights for women. a land records management information system was launched in 2016 in a move to increase transparency, accountability in matters pertaining to land ownership. And another initiative which was taken up by the Punjab government was that the property rights, when a husband purchases a house, the woman was also given equal, it was a 50-50 ownership to ensure and to give her economic empowerment. To increase women's awareness about their rights of inheritance and easy access to records through the LRMIs, to date 46 community meetings, 9 female seminars with representatives of female landowners, farmers and NGOs, and lectures in 4 women colleges have been conducted to create awareness. To date, 8 delinquent revenue officers have been punished as per law. The Women Development Department, Local Government and Community Development Department, Board of Revenue, Sexual Harassment, Ombudsperson's Office and PCSW have conducted extensive district and provincial level awareness campaigns on women's rights under family laws, prevention of child and forced marriages, women's right to inheritance, birth registration processes, and sexual harassment at the workplace. Discrimination against women, I have gone into that detail, but I would like to inform the August House that the key decision-making positions are held by women, such as Minister for State for IT. We have Anusha Rahman, Minister for State for Health and Regulation, Ms. Saira Afzal Tade, Punjab Minister of Women Development, Ms. Hamida Wahiduddin, and she is Pakistan, Japanese, so it is not only that it's Pakistan. Foreign Secretary, Ministry of Foreign Affairs, Ms. Tehmina Janjua, and many more. Sensitizing and awareness campaigns launched to aware women about their rights. It's an ongoing, continuous process which is going on with the facilitation of the NGOs, from NCSW, from Women Development. It's a continuous thing which is going, and it is creating a lot of awareness about their rights and about what's necessary. The National Commission on the Status of Women, in collaboration with stakeholders, there's a 16-day activism against gender-based violence. Various media campaigns in the whole are conducted. International Day for the Elimination of Violence Against Women is also celebrated every year for the last 3-4 years. The campaigns are participated in by government officers, social activists, legislators, diplomats, and representatives of media and civil society. NCSW, as an ongoing awareness campaign on pro-women laws and special campaign for awareness on laws to prevent gender-based violence, whereby laws related to acid crimes, rape, killing in the name of honor, early marriage, and sexual harassments. NCSW have organizations piloted the Pakistan Women's Media Complaint Cell in February 2014 to promote and ensure gender responsiveness within media houses. Then there are Rural Women Day conferences we celebrate. NCSW is in collaboration with civil society organizations celebrate the 2-day annual Rural Women's Conference attended by, there have been events over 1,500 rural women and NGOs and CBOs was held in Islamabad even for the last 3 years, and I have been attending them. And I see the difference. I see the awareness that is there in women. And I know that now they can come up, they can speak up. Before they were invisible, without faces, without voices. Now they have a face, they have a voice, and they come forward. And that is all because it is an encouragement by the National Women's Day and International Women's Day are celebrated. Girls' education is being promoted by the federal and provincial governments as well as by the civil society organizations, that is CSOs, under the Sustainable Development Goals. The government of Pakistan is committed to ensure inclusive and equitable quality education and promote lifelong learning opportunities for all. And we stand by our commitment. For this, physical infrastructure has been improved in rural areas in particular. New schools have also been built. A significant effort has been made to increase the number of women teachers and it has been made mandatory that women teachers would be at the primary level of teaching. Training programs to improve the classroom environment is going on, have also been strengthened. Numerous time-bound programs have been developed to ensure the enrollment and retention of girls, including the large-scale education sector reforms and education for all programs, both of which have gender-specific targets. Punjab Education Endowment Fund awarded 18,937 scholarships in 2013-14 and 18,650 till August 2014-15. Of these, 50% scholarships were given to girls across 36 districts of Punjab. Criteria for scholarships ensures sustained participation in education institutions. The Punjab Education Endowment Fund has been doubled the scholarship from 200 to 400 for students of Balochistan, you know, the far-flung areas where the restraints are there. It was included. The government is providing infrastructure facilities to improve girls' education through provision of free books in public sector school, feeder school facilities through National Commission for Human Development and Basic Education Community Schools are showing encouraging outcomes. The provinces are providing stipends, free books, nutrition support to girls' school. The Malala Fund for Girls' Right to Education was established under the MOU signed by the Government of Pakistan and the UNESCO headquarters in Paris on 10th December 2012. The Government of Pakistan has contributed US $10 million in the fund, out of which $7 million is allocated to Pakistan for girls' education in far-flung districts having high poverty rate and low girls' enrollment. The project's goal is to support the provincial area government's efforts in increasing access, retention, and improving the quality of girl education through targeted capacity building research and monitoring interventions at national level. There was a question that who is monitoring and seeing all what is happening. I think it was your question. Here I would like to see that the quasi-judicial powers of provincial and federal NCSW are there. One, to seek, they can seek and receive information from any official source or entity. To enforce attendance of any person and call for production of documents with powers of civil court guaranteed under the Code of Civil Procedure. 3, to inspect any jail, sub-jail, or any other place of custody with prior permission of provincial government. To intervene in institutional procedures for redress of violation of women's rights. And this is, and then there are embeds women and embeds women at both at the federal and the provincial level also, where ultimately the complaints go and redressal is done. Then the Women Development Department is there to oversee that the government policies are being carried out. As for the family laws, I would like to say that, the different on early child marriage, After the 18th Constitutional Amendment, provinces have enacted various laws to address the issue of early child marriage. And 18 and 16, as mentioned, was there that it has been passed by the Gilgit-Baltistan, Sindh, KPK is underway. But we cannot have, we cannot have extremist, radical, and overnight changes in societal behavior. It has to be gradual, incremental, and with the democratic blessings. Otherwise, I feel it's a draconian and unsustainable and likely to be ignored. We will handle our societal issues in our own ways so that our efforts are embraced by the people who we represent. But, the measures have been taken by the government in family laws, and amendments have been mentioned, as you mentioned, in amendment in 2015. It is an attempt to reduce the incidence of early age or child marriage in Punjab. Bill was passed. The age was retained, yes, but Act increases penalties for all parties involved in conducting, performing, directing, or registering a marriage of a minor. In 2015, the Muslim Family Laws Amendment Act 2015 was passed. The Act mandates filling in all provisions of Nikah-nama, or the agreement we have, and binds unlicensed persons to report a nikah, that's the agreement solemnized by them to the nikah registrar. And for this, to see that no unregistered person, there's a performer which has been developed for this registrar also. He needs to be, he is regularized and he's registered now with the government to carry out the nikah-nama. And failure to register a nikah carries a penalty of up to 3 months imprisonment and 100,000 fine. Penalties for polygamy also came up without the permission of the existing wife have been raised. Imprisonment and the fine has also been increased. The Act prescribes maintenance as an obligation of a father upon his children and penalizes in non-compliance. The Punjab Family Courts Amendment 2015 amended the Family Court Court Act 1964, an effort to speed up litigation and impose stringent liability upon a defendant for failure to provide maintenance. Monitoring and implementation of these provisions are being seen by the Provincial Commission for the Status of Women, as I mentioned. They are the body which, an independent body which is monitoring the government, and the complaints are being received by their helpline. To date, many complaints have been received, while 2,180 inquiries have been dealt on family issues. PCSW, which is the provincial, is a statutory mandated to take notice of cases of child and forced marriage. A mechanism is in place to register complaints by victims, tracking progress, and implementation measures introduced. Interventions by PCSW prevent polygamy, forced marriage, cancellation of nikah registrar's license. Police takes timely action against perpetrators. And here I would like to, say that in the end that our civil service is gender blind. When you are gender blind, you have true empowerment. For example, we had 4 ambassadors in our top for multilateral postings. New York, Vienna, Brussels, and Geneva had women ambassadors. They were there not because they were women, but because they were qualified and competent. That is gender blind empowerment. They are examples for millions of young girls in Pakistan to emulate. And Pakistan's record is both leading and exemplary, not just for 2 million Pakistanis, but for 1.6 billion Muslims. You know, we had the first Muslim women Prime Minister. We've had women Speaker of the National Assembly. We have the first women Foreign Minister in the Muslim world. And since we are talking about women in police, and here at the UN, let me tell you about Shehzadi Gulfam, the first women police officer to win the first ever UN award for peacekeeping. Whilst we have a lot of challenges, we have excellent examples for the world to follow. And I hope we can see the glass half full than to see the glass half empty. Thank you very much.
Thank you. Thank you very much.
Do we have just a couple of points, if I may?
5 minutes.
All right, even less if I can, with your permission, Madam.
Yes.
Thank you, Chairperson. Just a number of issues that were not, we've not had time to cover them, and as I said earlier on, we will try to send these in a written report. One was particularly about the measures taken by the State Party to address the repeated reports of abduction, killing and intimidation of journalists, human rights defenders and lawyers. I would like to highlight for the esteemed committee that in a thriving democracy like Pakistan, a free and independent media has become an important pillar of the state. We recognize that the robust role of the media can be gauged from the fact that there are over 100 media channels which frequently, non-stop, almost highlight political, social and human rights issues and lead the national debate on issues of public importance. Pakistan strongly believes in the freedom of press, of expression and of opinion. The journalists in Pakistan play an instrumental role for ensuring the freedom of press and fostering a culture of accountability, protecting the rights of the citizens and providing access to prompt and timely information to the public on all issues. The very nature of their work, journalists have often become the targets of the extremists and the terrorists. And the journalists have been the ones who unveiled the massive human rights violations perpetrated by the terrorists. And therefore, they're often the victims of the targeted killings and terrorist attacks carried out by the terrorist organizations, so that the voices against the scourge of terrorism can be silenced. We would also like to highlight to the esteemed committee that the unprecedented level of freedom of media that is available in Pakistan, and that all cases of intimidation and harassment of journalists is given immediate media attention itself, and then it is also addressed by the government, the parliament, and the judiciary. And wherever it is required, high-powered commissions have been set up to investigate the allegations of intimidation and harassment. The terrorists, as we all know, have been attacking everybody, and they've also been specifically attacking the journalists, the human rights defenders, and the lawyers. And therefore, the challenges notwithstanding, the government is taking utmost efforts to ensure the safety of the journalists so that they can carry out their work in a much more safe and secure environment. A number of measures have been taken, and if I may just, there's several we will share with the committee in writing. There's a Ministerial Media Security Committee with the specific mandate to suggest welfare measures to ensure the safety of journalists and the media persons. The government of Pakistan has initiated a new scheme of life insurance policy for the media persons, again for the welfare of the journalists. There's a hotline number, 111 925 225, has been installed at the Press Information Department so that the journalists can inform the government immediately about any potential threat to them or any security-related issue. And the government is also very cautious of its responsibilities and cognizant of its responsibilities regarding the expeditious hearing of cases of the martyred journalists, and agrees that the court cases of the affected journalists need to be heard by the anti-terror courts for a quick decision. There is also a proposal for the establishment of the endowment fund to provide relief to the wounded and crippled journalists who have fallen victim to terrorism in the line of duty. There's also a housing scheme for the journalists as well. to facilitate this very, very important profession. Furthermore, the government has drafted a Journalist Welfare and Protection Bill, 2017. It has been sent to the Law and Justice Division for legal vetting on 22nd of June, just a few weeks ago. It has already been circulated amongst the All Pakistan Newspaper Society, the Council of Pakistan Newspaper Editors and Broadcasters Association for their inputs. Therefore, we're consulting all the relevant stakeholders. Thereafter, it will be sent to the Law and the Justice Division for legal vetting, enabling that ministry to place it before the Cabinet for the approval. And the Ministry of Information, as I said earlier on, 5 minutes? Can I just finish just one point? One more minute. So the point of all of this is to highlight that the government is taking the role of the media, the role of the journalist, and the protection of this extremely vital part of our democratic society very, very seriously. And that was there's much more, but we can send it in writing.
Thank you very much. The floor is open for members for follow-up questions. Thank you. And then Monsieur De Foufil, and then Madame Grant-Carish.
Thank you, Madam Chair, and I would like to express my appreciation again to the delegation for the information they've provided. With respect to the freedom of expression in Pakistan, there was reference to Article 19 of the Constitution, and I just want to ask a question about the limitations that can be imposed on freedom of expression under Article 19. Article 19 provides that every citizen shall have the freedom of speech and expression, subject to any reasonable restrictions imposed by law in the interest of the glory of Islam or the integrity, security, or defense of Pakistan, friendly relations with foreign states, public order, decency, or morality, etc. Now, Article 19 of the Covenant, as you know, imposes very strict limitations on the restrictions that can be imposed on freedom of expression. Under Article 19.3, any limitation on freedom of expression must be strictly necessary for the protection of national security or public order or public health or morals. So I would welcome information from the delegation either now or in writing regarding how you interpret Article 19 of your Constitution consistent with Article 9.3 of the Covenant. And I was asked to provide names regarding eyewitness accounts of journalists, and I apologize for not having provided names before, but I was trying to be brief, and I will still try to be brief and also provide names. But journalists and human rights defenders who have reported harassment by Pakistani law enforcement and security forces. Amnesty International reports that in early January of this year, 5 human rights defenders were abducted from Islamabad and parts of Punjab province. 4 ultimately reappeared in late January. 1 remains missing. One of the defenders, Waqas Goraya, and we can provide the names in writing, has said that a government institution with links to the military held him and tortured him. The Pakistan Press Foundation reports that in July of this year, Abdullah Zafar, a staff reporter at The Nation, was taken away during an overnight raid at his house in Karachi, held for almost 20 hours in forced detention in a secret location. He indicated that security personnel in plainclothes dropped him near the international airport. The Committee to Protect Journalists reports a May 23, 2017 ruling from the Islamabad High Court restraining the Federal Investigation Agency from harassing journalist Taha Siddiqui, the Pakistan bureau chief for World is One News. June 25 of this year, journalist Zafar Achakzai was arrested by armed men, some in paramilitary uniform, others in plainclothes, who broke down the door to his home. He He was later charged under the Pakistani Electronic Crimes Act, reportedly for criticizing security forces regarding their handling of a hit-and-run case involving a provincial politician. His father indicated that the Frontier Corps, a paramilitary force, told him it had initially detained the journalist. And then finally in 2014, this does not give names, but it gives a reason, Amnesty International reported that dozens of journalists had complained to the organization of harassment, intimidation, or attacks by the ISI, that many had given information about harassment only on the understanding that it would be made public only if they were killed or kidnapped because of the fear of reprisals from the agency. So that is part of the source of information. And we would welcome any response regarding measures that have been taken to investigate or establish accountability if investigations prove substantiated. Thank you.
Thank you, Madam. Mr. De Fulfil.
Merci beaucoup.
Thank you very much, Madam Chairperson. And I would like to thank the delegation once again for the answers provided, in particular during this section of the dialogue. Because we received the greatest amount of information here, even though I would like to revert to some outstanding issues. And I would particularly like to thank Madam Chistemali for all of the information supplied on women in society and how much they have advanced and their status has advanced in Pakistani society. This is actually well reflected amongst the delegation. I don't think we've noted this up until now, and I think it's timely to point out that there is almost gender parity amongst the delegation, and that's something very positive. And you're quite right, you need to look at the glass that's half full rather than half empty. I think that's the expression we use in English. And so progress has been made. And here I'd like to revert to the CEDAW concluding observations, the Committee on the Elimination of Discrimination Against Women, which takes note of headway made, but also there are some remaining concerns. I have an additional question on this particular point. While rereading the concluding observations of the CEDAW Committee, the committee noted that it was concerned by the very little information provided on human and financial resources of the National Commission on the Status of Women to discharge its mandate, etc. Now, perhaps the delegation could give us some additional information there. This is information that has come to us from the CEDAW committee. The CEDAW committee didn't actually receive that information, but perhaps you could tell us a little more about the resources made available to the National Commission and perhaps also projects underway to strengthen this commission in what you've said, Madam. Now, there are a number of questions, and I didn't really get replies to them. I won't give you an exhaustive list because time is marching on. And of course, we won't be able to broach all issues here, but just let me mention a few of them. Perhaps, well, I don't know if I heard any replies on the issue of reservations to Articles 3 and 25 of the Covenant. And this highlights the issue of the provisions of the Constitution which were cited at the beginning of the dialogue and the provisions of legislation, particularly the Personal Status Code, the law on evidence or proof. Any amendments to, are you planning to amend them and to withdraw the reservations? I'd asked about setting up a national action plan on human rights. I think this is a very far-reaching question. Perhaps you won't have time to reply, but you could send the information in writing. I didn't hear anything about decriminalisation of sexual relations amongst adults and also the fight against discrimination in terms of LGBTI persons, generally speaking, because this is an issue which has been set aside in our discussion somewhat. These are two themes that are important: decriminalisation and combating discrimination against LGBTI persons, which is very important for this committee. Now, on enforced disappearances, just to come back to that once again, I'd like to thank the ambassador for having cleared up that point. But I don't think you replied to the two key questions which I raised. In other words, whether the state intended to further strengthen and bolster the resources of the Inquiry Commission. And let me say that the work undertaken is extremely important. It does very good work, but it needs to be further strengthened in its resources and independence. And then there was another question on impunity. The Commission undertakes very important work to track down people, but it doesn't address the issue of impunity and the perpetrators. Perhaps this is something that doesn't fall under its mandate, or it prefers not to deal with that issue. So these are some outstanding questions on enforced disappearances. Thank you very much, Madam Chair. And thank you also to the delegation once again.
Thank you, Mr. De Fulfil. Madam Brandkerk, please.
Thank you, Madam Chairperson. In view of the time, I will be extremely brief, but I would like to say thank you in particular for all the responses in this session, where I think we got a lot of additional materials. I wanted to draw attention to the fact, however, in the hope of receiving written materials, that there were no responses on the questions I had regarding minorities and minority representation, effective participation, including in particular also the voting, ensuring voting, effective voting access for Gypsies and Roma, and also for Ahmadis, but also the representation in the various bodies that I had already asked for. But I think it's a matter of time that we didn't get to it, so we appreciate the responses in writing. Thank you very much.
Thank you, Madam Brandkerk. And the delegation will have the time, this 48 hours, to respond in writing because time is up. I will invite the head of the delegation now to present his closing statement. Mr. Kamran. Excellent.
Action plan, which has been approved by the Prime Minister, and I hope it's been shared with you. There was this booklet of the National Action Plan on Human Rights and the dissemination about the covenants. So I hope it's with you, otherwise I'll give you my copy. But it has been passed and it's in process. So just to...
Distinguished Chairperson and experts of the committee, my delegation would like to thank you for an open and constructive dialogue. We commend the committee for the understanding and acknowledgement of our complex challenges, as well as appreciation of government's efforts. We have carefully listened to your questions and observations, keeping in mind the given time for review. We have made efforts to respond to the observations and queries which you have raised. Challenges notwithstanding, we reiterate our commitment to ensure civil and political rights of all without any discrimination. In line with the government's commitment, we would not only continue to implement laws and policies, but would also endeavor to allocate more resources for the promotion and protection of human rights in accordance with our international obligation and national human rights priorities, which include advancement of civil and political rights of our citizens. Distinguished experts, we take our international human rights obligation seriously and remain committed to implement the provisions of ICCPR, although promotions and protection of human rights would always remain work in progress for all countries. We assure you that we would continue to take legal, policy, and programmatic measures for the effective implementation of the Covenant and would be pleased to share progress with the Human Rights Committee we would make in our periodic report. We also attach importance to the work of human rights mechanism, including treaty bodies. We hope that the committee experts would continue their important work in a transparent, objective, and impartial manner. We also hope that while formulating concluding recommendations and observations for Pakistan, the committee experts would consider our responses, recognize our challenges, and keep in view socio-economic and regional context. In conclusion, we would like to thank the members of the committee for their valuable observations and constructive dialogues and engagements. We would also like to thank to the Secretariat and interpreters for their excellent work in ensuring a smooth review process. We look forward to receiving concluding observations and recommendations. Thank you very much. God bless you all.
I also thank you, and of course, the positive measures, but also the concerns will be reflected in the concluding observations. I wish you a safe trip back home. And you know we have the 48 rules in which you can submit written responses, which will be included in the considered as in the dialogue.
Definitely.
So I wish you well, and we close the meeting.
Thank you.